that's too intellectual for me, so I'll pass it off to these guys.
Yeah, that's probably my field, unfortunately. I suppose that applying that test that from the allergy pathway case, they could constitute an endorsement, because so long as you know, it depends on what might be, if there's something actionable in the tweet to begin with, and you know that perhaps it's untrue or something, for whatever reason, otherwise actionable, and you've got the power not to pass on that tweet, then applying Justice Finkelstein's logic, by passing it on, you're endorsing it, and you're potentially liable for anything that's actionable in it.
It would depend on context and employment sort of case. A lot of people on Twitter say retweets are not necessarily endorsements. There's some sort of legal caveat to Twitter use. I don't think that has much weight. If you could, I'm playing devil's advocate, if I'm an employer, giving permission for my employee to use social media on behalf of the company, then they start retweeting things that are quite offensive. There's two ways of looking at it. They're retweeting because it's offensive and they want people to react to it and respond, but the context will tell us that. The other is they are offensive themselves, and again the context will tell you that as well. It would be unauthorised use probably, and constitute misconduct.
Just pass around the microphone.
I think a lot of these situations, particularly the Accredited Act, obviously need to be incorporated. Let's say there's an employment contract, let's say in a statement of policies which governs the use of computers, internet, social media, and just lays down the rules like not using the firm stuff for private use, not saying anything derogatory or defamatory. So in that context, is it feasible to have provisions that the supervisor can go into the system and see what the employee has been doing in terms of meeting the obligations of the Accredited Act, and secondly, if the employee is doing private communications, is it appropriate the supervisor to be able to do that, or does that raise Privacy Act problems?
I'm glad you raised that. I was thinking about this last night. We are in the process of reforming the privacy law at the moment, which doesn't really help answer your question currently, but there is this new private cause of action that's being mooted by the current government. But not looking at the Human Rights and Discrimination Bill, looking at the OH&S Act, it says that employers must monitor conditions that are within their control. So you give a workplace, you've got a computer to an employee, you have a duty to, and that's their workplace and that's what they use. And in order for them to be safe, you need to monitor that, to make sure there's no OH&S risk. What if the employee becomes addicted to online gambling, and you've got internet at large, able to access all those gambling sites? Is that a breach of the duty? Should you ban? Should you monitor use? Should you ban online gambling websites? I think in online gambling, I think that it's a real danger in terms of controlling of the withdrawal behaviour. There's certain things I think where could kick in. Yeah, good question. It's a real issue. And I agree with your comment that these policies really need to be thorough and really get to the issue of what sort of behaviour on social media is expected.
I could add a few comments to that also. I read last night that the big issue of social media is in relation to recruitment, and it's standard practice for a lot of recruiters around the world when vetting candidates to right away go to their social media pages I'm not going to go into detail, but it does raise some of those questions in terms of privacy. And one that I found interesting was discrimination. I mean, inevitably you're going to come across an applicant's some personal or private issues about their age, race, some of their views. And if a decision is deemed to be made, whether not made in reaction to any of that information you came across, it's not a good look. So in Germany, I read this online, the federal cabinet has approved a draft preventing recruiters from viewing the social media profiles of applicants because there's actually no consent from the applicant for you to be going trawling through. And this does roll into gathering evidence. There's a lot of comment about that in terms of this is a practice of a lot of firms just right away once a case comes up. Bill made reference to it, and maybe we can talk a little further about that.
Well, there's also that thing of juries and social media and how you can control what a jury has before a trial and also what they get during the trial. And that's come up in a number of large trials, like the terrorism trial. The jury, even though they kept being told, don't go on your computers and search this, they keep finding bits of paper in the jury rooms where they've been printing out stuff from social media. And they're really vexed issues in terms of how you can control social media's interaction with the courts, as one example.
Yeah. Is there any other?
Yeah, I had a question.
Lovely. Thanks for going for
You've talked a lot about the benefits of social media, but to me, you have to have a clear purpose on how to use it. So if you want it as an information source, that's very well, but if you want to use it as a marketing tool, you've got to be careful because you've got to be fully committed to it. It's not a halfway job. Because if you're using it for marketing, for example, people will only follow people that they get value from. So if you put a tweet out every month or so, or a post, it's just not going to be effective for you. So it's good to know about, but you've got to be clear about how you want to use it. Is that
I'm not
fair?
sure about the true value equation because my children laugh because I have 4,000 followers and they think they just must be crazy because why would they bother following me? So it's, I think in terms of marketing that the voice has to be genuine. If you're going to use Twitter to market, you can't use it and say, use us because we'll help you get off an asset case. You've just got to talk about what interests you, and then either somebody's attracted to that and thinks that you're intelligent enough to be their lawyer or not.
Yeah, but you need to be, you have to do it quite frequently. It's a commitment, is what I'm saying. If you can't just expect people to arrive.
Yeah, sure, as a marketing tool, yeah, absolutely. Yeah, I'm not sure about how much, as a criminal lawyer, there are lots of people out there who get in trouble, and I've had maybe 2 cases that have come through Twitter over a couple of years, and we have a couple of thousand cases a year, I suppose, 1500.
It seems Facebook's generally the problem.
Sorry?
Facebook causes a lot more problems, is it?
Yeah, but I mean in terms of, if you're talking about marketing, that Facebook doesn't work for criminal lawyers because who's going to like you, really? Who's going to want that on your list? It's pretty unappealing.
If there's last questions before we... Yeah.
Thanks. In the aftermath of the Jill Mara case, when it was in the media spotlight last year, the Standing Council of Attorney Generals agreed that they were going to undertake a national project to investigate whether there should be some sort of government intervention or regulation around social media usage, particularly when it came to trials, in fairness of trials, and whether that would disadvantage the accused. I just wanted to know your thoughts, I guess directed to Bill, but open to the panel in terms of whether there should be government regulation around social media use.
It's a great question because it's just so hard to give an answer to. That some of the courts are looking at having television in there and videotaping stuff and playing it. And then you have some courts who say that's fine, but if you're going to play grab, it's going to be at least 2 minutes long. And all these issues are just getting talked about. My feeling is the horse has largely bolted, and say the Jill Maher matter and the application to suppress her information about the guy on social media, I just couldn't see the point of that. It was so, had already been in social media for a good week. Everybody who was interested already knew the amount of previous convictions he had and all the circumstances surrounding it. And some of you, not many of you, might be Herald Sun readers and seen the headline today, and it's about how Leigh turned up with 4 lawyers to apply for a suppression order on social media.
It's almost a bit like the underbelly that abandoned Victoria.
Yeah, we certainly tried hard.
Yeah, they got through very easily.
There were a lot of suppression orders. There's still a lot of suppression orders out there, but lots. Victoria seems to be one of the great suppression order states, and there are so many cases and so much information that I think the public should know that they are not told. And that's the fundamental objection going way off the track of social media to coercive hearings like Crime Commission and OPI. They're just wrong. Corruption thrives in shadows, and it thrives where bureaucrats, as they have the power to take you in and try and create a case. It's just nonsense. People should be more open. And, I mean, none of you here, if you were told what I knew, would not be able to have an intelligent view on it. So why should you be denied that? And I think that plays into the whole, whether you control social media. I think Victoria needs to have a good hard look at itself.
I think I second Bill's views on that. I think that all the regulation that all the law that currently exists is enough to be applied to the new media. So I think the Facebook, the allergy pathway case was really an application of an old defamation concept that published that came from 1937, then being applied to the Trade Practices Act from the 1970s in relation to social media, which is a relatively new phenomenon from the late 90s or early 2000s. So I think there's enough law there to adequately regulate usage. We don't need any regulatory response to new media.
I'd just like to thank the panel, and before I do, I would like to just say that it was really great to have this broad discussion. I'm hearing from all different sides of the legal profession, different specialty areas, as well as the questions. I think were fantastic, and it just is a real testament to the breadth and the range of issues and implications social media is having, and especially will have in the very near future. So if we could thank the panel together for